introduction to all the members of this board.
Yes. So my name is Mohit and I have done my graduation law from KCR Institute of Jalandhar and LLM from City University.
And then I'm from
City University, sir.
City University. Alright. Earlier also you appeared in any examination?
Yes, sir. In the year 2019, I appeared for the first time in Punjab Judicial Services.
First time.
Yes, sir. And then, sir, I have also cleared the AD examination, sir.
AD examination.
Yes, sir.
So what is their position for appointment?
Sir, the position regarding the appointment is laid before the Honorable High Court of Punjab and Haryana, and appointment has been halted due to this litigation.
Alright, we will ask some questions. Give proper answer. All the members, consider them, and the members of board at cleared out, because all those members are scholars. Therefore, don't give any wrong answer, don't bluff wherever you don't know the answer properly. Submit that. Give the answer slightly loudly so that it may be audible. The members may not pay unnecessarily extra attention to listen to you. Do you know about this order 35 of CPC? What is that? Order 35 of
Order 35 of CPC. Sir, it is with the interpreter suit, sir.
What is that interpreter?
Sir, interpreter suit is provided under Section 88 and Order 35 of the Civil Procedure Code. Sir, whenever a person is going to file a civil suit against the defendants, and he is having no right in the subject matter of the suit, but he is only claiming the charge of the property which has been in the custody of that person. That is known as the interpreter suit, in which the plaintiff is not having any right in the subject matter of the suit, sir.
Alright, such
Please define the offence of sedition and what is its current status in India.
Offence of sedition is provided under Section 124A of the Indian Penal Code, and it talks about when a person is going or attempts to commit an offence to take. It is somebody is going to make statement against the policies of the government in a wrongful manner, or is going to attempt this offence. This is an addition. This is a sedition. Every person is having a fundamental right to freedom of speech and expression under Article 19 of the Indian Constitution, but that is also subject to restriction under Article 19 subsection 2, which is public order, decency, morality, security of the state, relation with other states. That is why it has come into the controversy before the Honorable Supreme Court. If somebody is going to commit an offence, in Kedarnath versus State of Bihar's case, in this case also it was held by the Honorable Supreme Court that if somebody is going to commit an offence of sedition, that attempts will be bifurcated whether the attempt will come under the offence of sedition or not. So in the Honorable Supreme Court, the day-to-day hearing has been there in the
yes, recently some news are there.
Sir,
Regarding
as far as
this section.
yes,
What is that?
sir, as far as the new IPC is concerned, sir, the offence of
Not IPC, but the board Honorable Supreme Court.
Yes, sir.
Something is going to be discussed about this section 124A.
Yes, sir.
Sir, you know about this?
Sir, I'm not very sure about this, sir.
There is a constitutional bench.
Yes, sir.
Which is
It
going
has been
to
referred to the Constitution.
section 124. Yes, sir.
Can you tell us whether an interpleader suit can be filed by an agent
No, sir.
under any circumstances?
No, sir. It cannot be filed by an agent against the principal or tenant against the landlord under Order 35.
I think there is.
Yes.
There is one circumstance under which an agent.
Can you narrate that?
Sir, I can give one example of this, sir. If the principal has deposited his property or some money with some third person, and some third person is also claiming that property from the agent, as well as principal is also claiming that property from the agent, then in that circumstances agent can file interpleader suit.
Sir, you have claimed that because he has tried, but he could not come to the relevant point.
So you've given the example of a principal and agent, and the property is with the agent of the principal. And in this example, let's say the principal has mortgaged his property to a third party, and he has written a letter to the agent that now he holds the property as a surety for the third party. Only in that case, when the agent is aware that he holds the property as a security for the third party, in that case he can file an interpleader suit when both the parties claim the property.
Go through that. There is the exception also. That exception, go through thoroughly. Such type of question will be there.
What are the circumstances under which specific performance of a contract cannot be conducted, cannot be enforced?
Section 41 of the specific performance of the contract. When the person has obtained substituted performance from some third person under Section 20 of the Specific Relief Act, in that case he cannot obtain specific performance of the contract by the court. Second performance, where the continuous duty by the court is there. Like if some infrastructure project has been started by the government, in that case where the continuous duty of the court is there, in that case specific performance cannot be obtained by the court, or where the contract is based on the personal volition of a person, like singing or some dancing. In that case, ma'am, it cannot be granted by the court.
Yes, Ivana.
Okay, can you name any circumstances where a person is punished for causing harm to himself or herself?
Attempt to commit suicide, Section 309.
Yes, and one more.
Sorry, ma'am, I'm not recollecting.
All right. What is the order 27A of CPC?
27A of. It deals with the substantial portion of law as to the interpretation of the
Can you
Constitution.
explain that what is that? What type of suit is that? Whether it can be filed before district judge or
Yes, sir, it can be filed before the district judge as well, sir.
or before the civil judge.
Sorry, sir, civil judge, sir. Yes.
Civil judge will also.
Yes, sir.
Can you explain that what is that?
Sir, we have the portion before the civil judge is to interpret the provisions of the Constitution. In that, the civil judge can take the help of the Constitution of India and can interpret can be interpreted by the civil judge as well, sir.
Yes. What is order 21 rule 58 of
Sir,
CPC?
Sir, it deals with the execution of a decree. Sir, when objection has been raised by third person in the execution of some decree, that deals with order 21 rule 58, and there is a similar provision under section 47 of the Civil Procedure Code, but the basic difference, the objection under section 47 can be filed only by the party to the suit, but order 21 rule 58, here the third party can also file an objection. Even if the application has been rejected, or the civil suit or the civil judge who is executing that decree has refused to entertain the objection filed by the third party, under order 21 rule 58 sub rule 5, a civil suit can also be filed, sir.
Yes, sir.
Whether in any circumstance the voluntary intoxication can be considered as an exception under section 86 of IPC.
My pardon, sir.
There is always some knowledge attached to a person who is voluntarily intoxicating some particular circumstances, some particular substance. Now, that person can be quitted in any circumstance under section 86 of IPC.
Under section 86, as far as my knowledge is concerned, sir, only a presumption with regard to knowledge can be attacked. If there is an intention to do something, then he cannot be acquitted, he can be convicted, but as far as the knowledge is concerned, in that case, sir, he can be acquitted by the court, sir.
In case intention is not there,
Then he can be acquitted, sir, in except the circumstances.
Yes, Sanjay. You want to add that?
nothing, sir. He is right on this part that knowledge is always attached to a person who is voluntarily intoxicating particular substance.
Can you tell us something about Section 10 of Specific Relief Act with regards to the amendment and what the new section based on? It talks about specific performance.
Specific performance, yes, sir. So as far as the section 10 of specific relief is concerned, sir, discretion of the court has been abolished by the latest amendment of specific relief act, and it has been made mandatory on the part of the civil judge to grant the specific relief act. Only there are three circumstances like section 11 subsection 2, section 14 and section 16 in which the specific performance of the contract cannot be granted by the court.
And can you tell us what Section 14, Section 11, subsection 2 and Section 16, just briefly, what do they mean?
Section 16 talks about personal powers. Section 20 talks about where a sufficient performance has been obtained by the person. Or Section 11 subsection 2, if I am not wrong, sir, it talks about where the trustee has exceeded his authority and makes a contract with some third person.
And then Section 14.
Section 14. Sorry, sir.
You did mention it before to one of the members.
Substituting performance.
No, that's Section 20. Section 14 based on certain circumstances.
Certain circumstances.
Alright, Mohit. Suppose you have become a judge and you want to expedite the cases.
Yes.
What method you will adopt? Whether there are certain provisions which can be helpful to you for getting all the cases disposed of quickly?
So yes, sir. There are various provisions in the Civil Procedure Code. One is section Order 8 Rule 1, where the written statement is to be filed within a period of 30 days. And the second is, sir, the 3 adjournment rule provided under Order 17 of the Civil Procedure Code. By following these principles, the cases can be expedited by the civil judge. Other is, sir, by following the judgments delivered by the Honorable Supreme Court. There is Order 5 Rule 1 where a summon has to be served within a period of 30 days after filing the plaint. And
what is Order 17? You are referring to Order 17. What it says?
Sir, it says that only 3 adjournments shall be granted to the party. Other adjournment can be granted only in certain circumstances, sir. And sir, there is section 89 to.
Can you take any harsh action under this Order 17?
Sir, yes, sir. If
Suppose the party it is not presenting the evidence continuously for 3 years.
sir, a decree can be passed against him.
Then what will you do? Suppose plaintiff has not concluded his evidence. He has taken 5 of it. Now he is again making a request that one more opportunity should be given to him and he will bring entire evidence. Will you give any chance?
Sir, a decree can be passed against him, sir.
Decree can be passed. What type of decree? Suit will be decreed
Yes, sir.
in favor of the plaintiff.
Yes, sir. It can.
Plaintiff is not bringing evidence. When plaintiff is not bringing evidence, we should rather penalize him instead of passing decree in favor of the plaintiff. Otherwise, we will be here giving a lot of benefit to him. If we pass a decree in favor of the plaintiff who is not bringing evidence, keep that thing in mind so that your reply may not be contradictory. Because on the one hand, we say that he has not presented evidence, we can close the evidence. When he has not brought the evidence, certainly his suit is liable to be dismissed by virtue of Order 17. Order 17, under which rule we will dismiss his suit?
Sir, Order 17 Rule 2, I think, sir.
Rule 2?
Yes, sir.
Rule 2 is when some party is not present. It is Rule 3 which lays down that the court can pass an
As per Hindu Adoption and Maintenance Act, what are the essential conditions for a valid adoption?
Essential conditions of a valid adoption must be a person who is going to be adopted should be Hindu, and he must be under 15 years of age.
Other than that,
Other conditions are also laid down. If a person is a male and he is going to adopt a female child, then he must be. I'm not exactly reflecting that he must be above 21 years. He must be. There must be a difference between 21 years of age between both of them.
You want to add some more conditions?
There are many other conditions also with regard to adoption.
Yes.
Many other conditions. Can you describe all the conditions?
Not reflecting exactly.
All right. Yes.
If a person is going to adopt a son, the adoptive parent should not have a son or a son's son or a son's son, living or adopted at the time of adoption. And if they are going to adopt a girl child, then the adoptive parent should not have a daughter or a son's daughter at the time of adoption, either by birth or by adoption. Then you mentioned the marriage part, they should not be married, and the person should be less than 15 years of age, and the same person should not be adopted simultaneously by two or more persons.
Yes, Mohit, when you attain some opportunity, continue to speak. Consume the time. Otherwise, they will ask the questions if you stop somewhere. Because you know this, all the conditions.
Yes.
In the class, you used to take 100% marks out of this, and all the concepts were very clear in your mind. Now, bring that spirit, go through copies, whatever you have, and have full command over it. Your copy, if you revise the copy, that will suffice for it. Yes, Ivana.
Okay. Can you throw light on the concept of conjugal rights of prisoners in India?
Conjugal?
Rights of prisoners in India.
I've not heard about this man.
Yes, Ivana, give him some hints.
Conjugal rights means marital rights. So prisoners are also human beings, so they have marital rights, right to family, etc., right to enjoy a marriage. This concept is somewhat new in India, and no particular judgment is made for the same. But implied effects could be brought out from the judgment of Sunil Batra versus Delhi administration, because main focus of our criminal system is to attach a person with the mainstream society so that the person doesn't left out, because there is a life after jail also. So this is the concept of conjugal rights of prisoners in India.
With regard to this concept, let us discuss section 9 also of Hindu Marriage Act. What is that section?
So section 9 talks about the remedy of restitution of conjugal rights. Sir.
What is that?
Sir, whenever a wife or a husband withdraws from the society of the other spouse without any reasonable cause, sir, the other party is having a right to file a civil suit for the restoration of conjugal civil rights.
It is a civil suit or something else?
Petition, sir. Petition will be filed
No,
for the
but
district court.
under section 8 is petition.
Petition, yes.
It is not a civil suit.
Yes.
Whether this section was ever challenged before the Honorable Supreme Court
Sir, it was
or
challenged.
before some high courts?
Yes, sir, it was challenged before the Honorable Supreme Court of India, and it was held constitutionally valid by the Honorable Supreme Court of India in Atusma vs. Shesha Reddy's case.
Some high court has held that this section is unconstitutional. Which is that? Whether it is Delhi High Court, Bombay or Andhra Pradesh. Still not.
Sir, only this judgment was in mind to Shesha.
One question.
Yes, sir. Okay, do you know about the concept of parole? If yes, can you name any 3 famous persons who were granted parole?
Parole. Parole is basically, it comes under the rules made by the state government, and it is a release of a person for doing some religious duty or for doing some personal works, or for the purpose of doing some home related work, I think. And there one case which comes to my mind is the chief of Dera Sacha Sauda was released on parole.
Trying to know.
Not sure, ma'am. On this.
Who can release the accused on the convict on parole?
Sir, it is the state government, sir.
Now, there is whether or it is a judicial magistrate or session judge or some other authority.
Sir, I think jail authorities.
Jail authorities.
Yes, sir.
Jail authorities competent or some deputy commissioner.
Sir, with regard to
They have given power to the deputy commissioner in various you change the place with the Kaulji. Sir,
Can you throw some light on the concept of adverse possession?
The concept of adverse possession is provided under section 27 of the Indian Immigration Act. Sir, at the determination of the prescribed period for filing a suit for getting property back from someone, if that period has been elapsed or has not, and the civil suit has not been filed within a period of this period, the period is provided under Article 65, 64 of the Indian Limitation Act schedule. And if the civil suit has not been filed, then his right shall be considered to be over. And
adverse possession is also relating to movable property or not?
no, sir, it is only related with
It is not. Movable property is not covered under section 27. In section 27, whether specific word is written that it is immovable property.
No, sir, it is not written, but from the judgments, it is clear that it is only livable property.
Movable property is also there. If somebody has not claimed his movable property continuously for more than 3 years,
Yes, sir.
then certainly the opposite party attains the right. It is applicable to movable property also. I'll go through that section 27, then make sure whether it is applicable only to immovable property or it is related to movable. Yes, Kaul.
Can you explain what is self-sanction?
Self-sanction.
Sanction.
Self-sanction.
Self-sanction, not sanction or the sanction. What is sanction? What do you understand by sanction? Word sanction.
Sanction means to give one's assent or consent to something.
Permission.
Yes.
Whether a public servant is prosecuted without sanction?
No, in the criminal procedure code there is specific provision under section 197 that a public officer or public servant can be prosecuted only after obtaining the permission or the sanction of it.
In all the offences,
No,
the sanction is required.
No, sir, with regard to section 376, 376A, B, C of the Indian Penal Code in that cases, or section 354 outraging the modesty of a woman, in that case, sir, permission is not required.
There is no necessity to get a sanction.
Please explain the concept of constructive res judicata with landmark judgment.
So the concept of constructive res judicata is provided under section 11, explanation 4. Sir, it talks about, it is known as artificial res judicata. It is also one of the form of the res judicata. The landmark judgment over this is the Watson vs. State of Duties case, in which if a person has not taken the plea of attack or defense in his civil suit or in the writ petition which has been held in this case, then he will be barred to take the plea in the subsequent suit.
So let's say a person has gone to the police to get an FIR registered and the police has refused to register an FIR. Can you tell us what remedies does this person have?
Sir, if the person has gone to the police station to register an FIR and the police officer has refused under section 154, then first remedy he can file an application to the superintendent of police, subsection 3 of 154. Or if at the same time he is also entitled to file a criminal complaint under section 200 because it deals with both cognizable and non-cognizable cases. He can go for the application before the superintendent of police, or he can file an application. He can file a criminal complaint under section 200 before the magistrate.
Can you also go to the High Court in any circumstances?
Sir, there was one case that under section 482 of the inherent power of the High Court can give direction to register an FIR, sir.
Generally, it gives a direction to the police station.
No, sir, in general, I think it is not in practice.
No, every case's remedy is under section 156 subsection 3.
Yes, sir.
Because it is a judicial magistrate.
Sir, as far as my knowledge is concerned, sir, first of all, the criminal complaint has to be filed under section 200. or then the magistrate, before taking cognizance, he will refer the case under section 156 subsection 3 to investigate the case, and it is the duty of the police officer to register an FIR first of all, then investigate the case.
Can a grieved person simply file an application
Yes,
for
sir.
the registered under section 156?
Yes, sir, it can also be filed.
There is no need to file
Yes.
it. It can be done in this way also. Yes, Kaul.
Whether an affidavit can be amended?
Affidavit under in civil cases it can be mandated. Even if I'm not wrong, recently there was an amendment in Order 18 that examination is in chief shall always be by affidavit.
Yes, it can be by affidavit, but under if an affidavit is given under Order 18 Rule 4, then it cannot be amended. Otherwise, an affidavit can be amended, and both affidavits are having equal weightage, and the more weightage will be given to the that affidavit, which is according to the merits of the case.
Now, once affidavit has been filed in the court, that is evidence on oath.
Yes.
Can it be amended in that circumstance?
Sir, I have not understood the question correctly. So it cannot be amended, sir.
Because evidence
It is always on oath, sir. Yes.
is known by that evidence.
Constitution grants protection to persons accused of offences in respect of conviction. Can you name those protections?
Can you repeat the question?
The Constitution grants protection to the persons accused of offences in respect of conviction. What are those protections?
Is there any article which is referring to that?
After conviction, Article 72, we can he can file a mercy
Whether it
petition.
can be 20 article.
Part 3 of the
Yes.
Constitution.
Article 20 talks about the ex post facto laws and double jeopardy as well.
Now, she is asking this question with regard to double jeopardy.
Sir, question.
Double jeopardy.
Sir, yes, sir, double jeopardy. If
What is double jeopardy?
Sir, it is provided under Article 20, Sub-Article 2 and Section 300 of the Criminal Procedure Code. When the person has already been convicted and acquitted by the court of competent jurisdiction, till the conviction and acquittal remains in force, the person cannot be prosecuted again for the same offence, sir.
Yes, what is the collegium system in our India?
Sir, collegium system, there are 5 judges in the collegium system. The Chief
Where
Justice.
it has been provided in the constitution?
Sir,
In some article or?
Sir, there is a reference of collegium system in Article 124 of the Constitution.
Is there any word of collegium?
Sir, they have not written the collegium system, but
word
the
has never
reference.
been
Yes,
used in our constitution.
only the
But
reference.
it is the creation of Honorable Supreme Court. How you will explain that collegium system?
Sir, it is a system by which the judges of the High Court are promoted to the Supreme Court, or by which the judges of the High Court and the judges of the High Court are transferred, and this is the system of collegium system.
How it was created? Whether Parliament has passed any law on this or not?
Sir, with regard to collegium system, I am not very sure, but there was one controversy regarding the National Judicial Commission and the collegium system, sir. So,
Who has evolved this first time?
sir, it was.
This collegium system. We have done this at class. We discussed in detail. If you go to the constitution copy, then you will be surprised that you have written everything there.
Yes.
It was first time created by Parliament, National Judicial Commission or some other authority. Yes, Sanjay. Will you say something? You have heard that. Sai?
So the collegium system was first created by the Supreme Court.
It is only Supreme Court which has created first time by authorizing the appointment by a body of firstly 3 members, then it was increased. Yes, I will.
So with respect to FIR again, is it compulsory for a police officer to register an FIR? Whether you can name any judgment with respect to this?
Sir, as far as the FIR is concerned, as per the authority of the Lalita Kumari versus Government of UP, it is mandatory for the police officer to register an FIR in cognizable cases.
And are there any circumstances mentioned in that judgment that say that the police may first investigate into the matter and
Sir,
then?
preliminary investigation or inquiry can be conducted in matrimonial cases, corruption cases, medical negligence cases, or where there is a delay of filing an FIR.
Make reference of this, that where they can conduct a preliminary inquiry.
Yes.
By the police. Yes.
Where a document is required to be registered, but it is not registered, what would be the effect of non-registration of that document?
If the document is required to be registered compulsorily, then it will not be taken as an evidence in the court. But there are two circumstances in which it can be taken as an evidence for the purpose of collateral transactions or for the purpose of specific performance of the contract. Section 49 deals with this concept.
There are two other consequences of
It will not transfer any title in the immovable property, I think.
and it will not confer any power to adopt.
Kaul.
Please explain section 436A of CRPC.
436. 436A of CRPC deals with when a person has already undergone an imprisonment, which is maximum provided for the offence. He will be entitled to file a bail application before the court. And the second, if he has already undergone an imprisonment which is half of the maximum provided for the offence, then he will also be entitled to file a bail application before the court. It is specifically provided in section 436A.
Can he be held in further detention also in any case?
Yes, if I think there is one circumstance where I think public prosecutor makes a reference and appears before the court that he should be required for some other purpose as well. He can be detained.
Yes, Mohit. Say something about interrogatories. What are the interrogatories?
Sir, interrogatory is provided in the Civil Procedure Code. When a person has filed a civil suit,
It comes under which provisions of CPC?
Sir, Order 11 of Civil Procedure Code, sir. Yes, sir.
Is there any section also?
With regard to interrogatory, there is no section in Civil Procedure Code, sir.
Is there not supplemental proceedings?
Supplemental proceedings, there is section 94 is there, sir.
This is referred there.
Yes, sir.
And it can be.
Yes, sir.
Alright, what is the interrogatories?
Sir, interrogatory basically are questions framed by the court on the basis of the information given by the plaintiff, and these questions are referred to the defendant in order to save the time of the court or in order to save the money and expenses of the plaintiff. Sir, the questions are framed and the court seeks a reply on these questions, and it will reduce the burden of the court as well, and it will also help that no further evidence will be required in the court for proving the case.
Interrogatories are delivered at which stage? Whether after filing plaint,
Sir, it will be after filing plaint, sir.
whether it is after written statement,
No, sir, it will be after plaint, sir.
only after plaint,
Yes.
whether
It can be, sir, after written statement as well, sir. But generally it is after the filing of plaint.
Not. It is only after framing issues when there is a controversy.
Yes.
When there is a controversy, only then the question arises.
Yes.
That let us ask some question from the other party in order to prove those controversies. I'll go through that order.
Yes.
11. It will give the stage, that is the stage. Decide.
So Mohit, in a civil suit, a decree has been passed in favor of the plaintiff and he has filed for execution of that decree. Now can the court which is executing the decree go behind the decree and look into the judgment passed by the court?
So generally executing court cannot go behind the decree. But there are circumstances in which if the judgment has been passed against the dead person, in that circumstance he can go behind the decree. If some fraud has been committed and that fraud has come brought before the executing court, in that case, sir, he can go behind the decree.
Whether these conditions are provided anywhere?
Sir, section 47 has a reference that executing court will deal with three issues only, that is execution, discharge and satisfaction. And further, there is no other ground on which the executing court can deal with. So I think, sir, this is the only section.
So these two examples that you have given, they are based on what
Yes.
principles?
They have been given by the judgments given by the Honorable Supreme Court, sir.
Yes, here this, that it is the various judgments of the Honorable Supreme Court,
Yes, sir.
which had created these conditions.
Yes, sir.
Yes, sir.
What is the concept of commutation of death penalty and of commutation of life imprisonment? What do you mean by that?
Sir, commutation of death penalty and life imprisonment is provided under section 433 of Criminal Procedure Code. If death penalty can be commuted into life imprisonment or for fine as well, or life imprisonment can be converted into an imprisonment in terms of years, or it can be for fine as well. But there is a bar under section 433A of the Criminal Procedure Code. When a death penalty has been commuted into life imprisonment, and life imprisonment, then a person cannot be released from bail unless he cannot be released unless he has served at least 14 years in jail.
Very good, Mohit. You are given right answers. But prepare yourself well. Make the concepts crystal clear, so that you may not stop here and there. Make the concepts clear. Now go through the copy which you have prepared. That will serve us. Moreover, try to go to the court also, to discuss with the advocates also. Try to get some time to argue before the court, so that your agitation will be removed. But you have tried your best to remove your agitation. It is good. We wish that in this time you must sit on the seat of a judge. We will call you in the class also for some time. Yes, students, let us move to the class, and we will be there after 10.